Good evening, everyone, and welcome to this seminar on estate planning. My name is Chuck Denninger. I'm a member of Lord of Life, and I'm also a member of the Endowment Fund Committee. This is more of an education type seminar and awareness, and working with Bobbi Hermanson-Albers legal firm gave a similar presentation like this 3 other times at our church the last couple of years. Pastor Peter, you want to make a few comments?
It's really good to be with you. Thanks. And thanks to Bobbi for doing this with us. And I just want to say, so I have a new part of my job description, and that's going to be relating to the endowment committee because of relationships I have and that sort of thing. But I'm happy to be here now. And Pastor Chick and the committee did a great job of setting everything up. So if you do decide to get involved with our endowment, it's really we're well positioned, I think, to really grow it. And so that's going to kind of be my job description.
Okay, Bobbi, the floor is yours.
Thank you, everybody who is joining us tonight. I'm thrilled that there are so many of you. My name again is Bobbi Hermanson-Albers. I'm one of the estate planning attorneys at Barna, Guzzi & Steffen. We office here in Coon Rapids, but with everything that's going on, a lot of us are officing outside of our homes, and we're making it work just like everybody is. And as Chuck mentioned, we've had the opportunity to speak to the Lord of Life congregation on multiple occasions. I believe this is our 4th time. And I hope that the information I provide to you is helpful and at least gives you an idea of what steps you might need to take in terms of your own estate planning, and just some thinking. You can start the process of at least thinking about it and making your plan when you're ready to do that. Feel free to reach out and ask me questions. I'm always at my desk. I'm always willing to answer my phone. I'm not one that lets it go to voicemail. So if you have a question, please feel free to reach out. I've been working here with Barna Guzzi for just over a year. So I haven't been here really long, but I've been an attorney since 2014. So estate planning, it's a word you hear all the time, but I thought it might be helpful to explain exactly what that is. Basically, estate planning is making a plan now to determine how your assets are going to be divided to the people you care about and the charities and churches you care about and the organizations you care about at the time of your death. So planning ahead makes sure that you kind of get to control how those things get distributed. And there are multiple methods of, controlling how these things get distributed. The first of which is by a beneficiary designation. A beneficiary designation is something you've probably all completed for your life insurance policy, maybe your 401k, a bank account, anything like that. And by making or completing a beneficiary designation on your asset, what you're doing is you're making that asset what's called a non-probate asset. And what that means is by naming a beneficiary on that piece of property, that property is going to automatically flow to that beneficiary upon your death. And that asset is not going to be subject to a probate proceeding. And a lot of the estate planning that we do is to try and find ways to make it less complicated if you're going to have a probate proceeding. So we always recommend to our clients, if you have an asset where you can name a beneficiary, do it. It makes sense. It doesn't cost anything usually. And again, it's going to convert that asset to be a non-probate asset, and it's not subject to the court proceeding. The important distinction about beneficiary designations that I thought was important was when it's not subject to the probate proceeding, it's not governed by the terms of your will. A will only governs probate assets. It doesn't govern the assets that have beneficiary designations. So when you have a beneficiary designation, I'm just going to give you an example. Let's say I have Lord of Life Church as the beneficiary of my life insurance policy. But in my will, I say I want the residue of my estate to go to my 2 children. that beneficiary designation is going to trump the terms of your will. So even though they're different, the beneficiary designation is always going to trump what's in your will. The next method that we use is the will. So you're going to have assets that you can't have beneficiary designations on, or maybe you just don't. And anything that doesn't have a beneficiary designation and anything that you own as an individual at the time of your death is going to be governed by your will and distributed according to the terms of your will. So let's just say, for example, that you have a home and a business. You don't have a beneficiary listed on those assets. You're going to have to go to the probate court and have a probate proceeding for somebody to be appointed to distribute those assets according to the terms of your will. And we're going to dig a little deeper into wills in a minute, but that's basically the second possibility. And the last possibility is the use of a trust. And the trust, there are several kinds of trusts, but we're going to focus today just on a revocable trust, which is the most common type of trust that we help our clients set up in terms of estate planning. There are lots of other types of trusts. And if you came and met with me and I thought there was a good reason to use a different type of trust, I would definitely talk through that with you. But we're going to focus today on revocable trust. And what happens with a revocable trust is you're setting up a trust during your lifetime. You're funding that trust during your lifetime. And basically what you're doing is you're transferring ownership of your assets that you own as an individual to trust ownership. You're transferring it to the trustee of your trust. And the purpose of doing that is to make those assets non-probate assets, just like a beneficiary designation. By transferring ownership to the trust, you're basically saying, okay, I don't want these assets to be subject to a probate proceeding. I'm giving ownership of it to the trustee. And under the terms of your trust, you're saying, my trustee, if something happens to me, is this person. So the trust survives your death. And so there's no lapse in ownership that's caused by our death. The trustee continues to own our assets upon our death. So I kind of went through this a little bit, but again, the will governs only our probate assets. And a will really doesn't have any effect unless you're in probate court. So if you have a whole bunch of beneficiary designation, assets with beneficiary designations, and then, let's say you have your home, and you don't have a beneficiary on your home, you're going to have to go through a probate proceeding. And what that would involve is taking a copy of your will, providing that to the court, and then setting a hearing, or possibly administratively. I won't go into the details of that. There are multiple types of probate proceedings. But basically asking the court to appoint somebody as your personal representative to distribute the assets from your estate according to the terms of your will. Personal representative has no power to do that until they're actually appointed by the court. Sometimes we see people here that come in and they're like, we haven't had a probate proceeding, but my brother is locking us out of the house and doing all of these things. And so, I always tell people, you have to have a court proceeding to get authority to do stuff like that. So that's kind of what the process would be to initiate a probate proceeding. But if something ever happens and you're wondering, is probate actually necessary? It's a good idea to schedule a meeting with an estate planning attorney and go through it. Because it very likely could be that a probate proceeding isn't necessary because the assets had beneficiary designations, or they were in a trust, or the home had a transfer on death deed, which is something we'll talk about in a minute. So the will is really going to only govern those probate assets, not the assets that have beneficiaries, not the assets that are in the trust. Wills are a really good thing for everybody to have. In my opinion, it should always be your backup plan. Even if you have a trust and you're funding everything into your trust, when we draft a trust, we always draft a companion will to go with that trust to make sure that In the event there's some asset that didn't quite get properly funded into your trust, your will is going to pick up where your trust maybe can't pick up. So in Minnesota, a probate proceeding has to be commenced under very specific circumstances. I'm not going to go through every single one of them, but I'll give you the 3 top circumstances where you have to have a probate proceeding, and there's no way around it. The first circumstance is where your probate assets, all of them combined, the value of them exceeds $75,000. So, you know, your stuff in your house, your garage, your vehicles, all of that usually isn't $75,000. You know, we give it garage sale prices and give our best guess on what it's worth. But maybe if you have a bank account that has $50,000 in it, and then a retirement account that has $5,000 left, it might add up to $75,000. So it's important to kind of walk through that. What are my probate assets? How much are they worth? Because if you have probate assets that exceed $75,000, you're going to have to go through a probate proceeding. I can think of cases where we've had clients who had a trust. They did all of, you know, took all of the steps to avoid a probate proceeding, and they named their beneficiaries on their assets. I can think of one in particular where it was literally about $75,400 in a retirement account. The beneficiary designation wasn't properly completed. So despite all of this, you know, person's good planning, we had to go to the probate court and get the personal representative appointed. So part of our process when we work with somebody to complete their will or any type of estate plan is we go through each of the assets and determine what do we need to do to address each of these assets. And the final step I always tell my clients is go check all of your beneficiary designations and make sure that they're actually still valid. If they're not, fill out a new form. And that's always the last kind of final step of your estate plan. So sorry, I'm jumping around a little bit. So again, number 1 is when your probate assets exceed $75,000. The second circumstance where you're going to have to go to probate proceeding, no matter what, is if you own a piece of real estate or have an ownership interest in real estate at the time of your death. So ownership interest in real estate could be many different things. It could be you own a home, a cabin, you know, vacation home. It could be mineral rights to land. I recently did a probate for someone who had mineral rights to real estate. It could be just farmland that you lease out to local farmers. Any interest in real estate that you own as an individual that doesn't have a transfer on death deed on it, which we'll talk about again in a bit, has to go through probate. Even if it's under $75,000 in value, it still has to go through probate. And if you think about it, it makes sense, because if you own real estate, you have a title with your name on it that says you own the real estate. And when you pass away, nobody has legal authority to transfer or sell or do anything with that real estate until the court appoints somebody with that authority. So that's why the rule exists for real estate. If you own it as an individual at the time of your death and you don't have something in place where it automatically transfers to somebody else, you have to go through a probate proceeding. And the final most common reason that people have to go through the probate proceeding is when they pass away and there's no surviving parent of minor children. Whenever minor children are involved, no matter what you've done, you have to go through the probate process. And that makes sense. The court wants to make sure that children are taken care of, that you know, Auntie Sue isn't going to take all the money and go to Vegas and have a good time, that the money is going to be preserved for the benefit of the children. So a will is a really, really good idea if you have minor children. I have 3 minor children. my husband and I created a will, and what we've done is we've said, okay, if something happens to me and my husband survives, of course he's going to be financially responsible for my children and their support, and also he's going to be there, be in charge of their care, their shelter, and all of those things. He'll provide the care for the children if something happens to me. If something happens to both of us, however, our will says we want my sister, the person my husband and I chose, to be the guardian of our children. So if you have minor children, it's a really good idea to have that will in place to nominate somebody to be the guardian of your children. And while nominating somebody as a guardian isn't a surefire way to say they're absolutely going to take charge of the children, the courts are going to give it a lot of deference, because as a parent, you know who's going to take good care of your own child or children. So those are the three scenarios when probate proceeding is almost always going to have to happen. So the next tool that is commonly used is the revocable trust. And as we've discussed, when we name beneficiaries on our assets, those assets become non-probate assets. Also, when you transfer your assets to the trust, like I said, those assets become non-probate assets. By transferring ownership to the trust, again, you're avoiding the probate because there's no lapse in ownership that is triggered by our death. That ownership continues seamlessly, and the trustee continues to control the assets, and upon, usually the terms of the trust will trigger some sort of distribution or something to happen that's triggered by the death of the settlor. You could sometimes hear the term settlor or grantor. That's the person that sets up a trust and the person whose assets are funding the trust. So a revocable trust is different than an irrevocable trust. A revocable trust is exactly what it sounds like. I have a revocable trust. If I decide that I want to terminate my trust, I don't want it anymore. Let's say my husband and I get divorced. I hope that doesn't happen, but if it does, we probably don't want a joint trust anymore. So we decide to terminate it. We have the absolute right to do that. Clients often come in and they have the idea that I don't want to put my money in a trust because, or my assets in a trust because then I can't touch them anymore. That's true for an irrevocable trust, but not for a revocable trust. And the revocable trust is often used to avoid the probate process. An irrevocable trust is something that elder law attorneys and other types of attorneys, and even our office sometimes will do when somebody maybe has concerns about qualifying for Medicaid or medical assistance or nursing home care, and they want to protect their assets. That's a whole nother conversation we're not going to delve into very deeply tonight. But the revocable trust is basically just transferring ownership of the property to yourself as trustee of your own trust. So my husband and I transferred our home to our trust and our other assets. But when we get our statements from the county now, like our tax statements, we're listed as trustees of our trust. We're not listed as individuals. And if we, like I said, if we decide to sell it, we decide to take out a loan against it, we can absolutely do that. Just the fact that it's in a trust doesn't inhibit our ability to do those types of things. It's really pretty simple. It will help avoid probate, and that's our intent. And it's also to simplify the process and make sure that we don't have assets all over that are, kids need to round up and figure out. It's all in one place and it's simple. There are many situations where Bill or I might recommend a trust. It really is going to vary person to person to person what options we may recommend. We'll always give you all of your options, but I usually try to say, I think in your situation, this might be a better plan given, what you're telling me. But some of the situations where revocable trust really makes sense is when a client has minor children and they have assets that are titled, like a piece of property, an interest in a business. under Minnesota law, minor children are not allowed to inherit anything. They're not allowed to be beneficiaries on things without having to go through a court proceeding to appoint a guardian and conservator. So setting up a trust allows the trustee to manage their funds until they're grown up and they reach the age that you decide is appropriate for them to receive the funds that are in the trust and the assets that are in the trust. Some people think, well, I don't want my 18-year-old to get a lump sum of everything I have, when they turn 18. But when you set up your trust, you have so much control over how and when the assets are distributed to your children or grandchildren. You might say, okay, I don't want them to get anything until they're 30, and then it's one lump sum when they're 30. Some people do it in phases where they're going to get 1/3 of whatever's in the trust when they turn 25, then they're going to get half of whatever's in the trust when they turn 30, and then whatever's left over in the trust at age 35 is going to be distributed out, and then the trust will terminate. So there are lots of different options for whatever is appropriate. I know my children aren't getting anything until they're kind of through those college years and well on their way to adulthood. The other thing you can do if you have minor children is make the trust the beneficiary of your life insurance. So just to paint what that looks like, if something happens to me, my husband is the beneficiary of the life insurance policy on my life. But if something happened to both of us simultaneously, I can't name my children as the beneficiary of the policy because they don't, under Minnesota law, they can't inherit anything. So what I've done is I've named the trust for the benefit of my children as the beneficiary of the life insurance policy. And you can do that even if you don't have minor children, you can do that. But sometimes it's quicker just to name the beneficiaries if you know exactly who they are. But if you want it to be administered through your trust, you can always name the trust as the beneficiary. Another situation involving children where it makes good sense to use a revocable trust is if you have a child with special needs. If you have a child with special needs and they reach that age of distribution where you would normally give whatever their share of the trust assets are to them, that could inhibit their ability to qualify for assistance. So if they're getting, medical assistance or some other type of assistance where they have to qualify by their assets and income, a trust that distributes a large sum of money to them could really interrupt their coverage. And we don't want that to happen. So what we can set up through a trust is what's called a supplemental needs trust, where you're not giving them control over the money, which is what they need to not be able to do to qualify for that type of assistance. Instead, you're saying, okay, I'm going to appoint a trustee to manage the money for them. And if, let's say they want to go do something fun, they want to, take a vacation, you can use the funds in this trust to make sure that they're able to do that without jeopardizing their qualification for assistance. So that's a really good use of a trust. There are many other situations where a trust might make a lot of sense. If somebody has one piece of property, it's their home, and they don't really have any other assets that would be subject to probate, a trust is a good option. It's always a good option, but it might not be the only option. A transfer on death deed that we'll talk about in a minute might be another good option. But if somebody has multiple pieces of property or interests in land or a business interest, any other types of interests that don't have beneficiary designations that we need to worry about, a trust is a really good option. It just makes it simpler for everything to be in one place and makes it easier to administer. And it has that added benefit of avoiding probate at the end of the day. So just kind of summarizing again, the benefits of a trust include keeping those trust assets out of the probate process. And another benefit of a trust is when you're outside of the probate process, you are able to maintain a little bit more privacy. than if you're going through a probate proceeding. So probate proceedings are public proceedings. Anybody can sit in on them. There are people that actually go to court and they sit through hearings all day just because they think it's interesting. I've had clients before where privacy is a really important thing to them. They don't want their finances in court, public court record. So in that sense, a trust is good because when you're outside of the court process, you're able to maintain more privacy than when you're in it. Tax planning. So if you're a really high asset, person, you have millions of dollars, trusts can also allow you to do some tax planning to try and minimize estate planning tax exposure and plan ahead for taxes of the estate by assigning certain things to certain places. I'm not going to dig too deeply into that, but if anybody wants more information about that, I'm more than happy to answer any questions you have and walk through it with you individually. But the last thing that is, it sounds like a no-brainer, but it really gets missed a lot, is when you set up a trust, the most important thing you can do is actually transfer your assets and fund it. If you set up a wonderful revocable trust saying exactly what you want, but you don't actually transfer your assets into it and fund it, the trust doesn't have anything to distribute at the end of the day. And those assets that you intended to transfer in there are going to be subject to probate, despite your best intentions. So one of the things that we always do as our final step after talking through everything is make sure your assets are addressed. Are they in the trust? Do they have a beneficiary designation? If not, you understand they're going to go through probate. Should we talk about some additional options we might want to consider to avoid the probate proceeding? And I keep talking about avoiding probate. I feel like I need to step back a minute and clarify one thing. Probate is definitely not a bad thing. And, like I said, it's a public proceeding, but there's nothing wrong or, you didn't fail if you have to go through probate. And it can be a really quick and easy process, but it's not as quick and easy as if you didn't have to go there, because you have to wait for the hearing to be appointed as the personal representative. You have to get some publication of notice to creditors out there. There are lots of steps in it, but it's totally doable, and not everybody is that concerned about having to go through probate. So a will that addresses probate assets is totally appropriate for some people, and they're comfortable with it. One of the things we like to do here is just make sure you understand exactly what will happen based on the way your assets are set up, and make sure that's how you want it to go. And if it isn't, we'll figure out a way to try and get it closer to what you think it should be. So the beneficiary designations. The payable on death beneficiary is going to be something that you see on your bank accounts, on life insurance. Transfer on death is going to be something with investment accounts. These are all the same thing. You just hear these terms thrown around. They all do the same thing. What they're doing is they're making probate assets, non-probate assets, keeping them out of when we're talking in terms of estate planning. A beneficiary designation is a beneficiary designation. So these all accomplish the same thing. Quickly, a transfer on death deed is a deed that basically allows you to name a beneficiary on your property. It's appropriate in some circumstances and not appropriate in others. And it's not appropriate in my situation. I have minor children, so I couldn't name them as the beneficiaries of my real estate. If something happened to me while they were still minors, they couldn't take it. They couldn't take possession or own the property. So it's not appropriate if you have minor children. It's not an appropriate situation where you have a family with 10 children, because every single beneficiary is going to have to sign off on every little closing document, and it's a logistical nightmare when there's more than four beneficiaries or so. It doesn't make sense if you have children who are butting heads. We get situations all the time where siblings can't get along and they can't cooperate to get the most simple transfer documents done. So if you have beneficiaries that tend to butt heads a lot, probably not a good idea to use a transfer on death deed. Really good situations are going to be you have three adult children that get along great. You know that when they need to sign documents, they'll do it quickly, they'll be responsible. Those types of situations, it's a great option. And basically what we do is complete this deed, and we record it with the county where the property is sited. And upon death, all the beneficiaries need to do is file an affidavit and proof of death with the county, and then the title automatically transfers to their names. Planned giving to Lord of Life. For all of us that want to leave anything to our church and our other organizations we care about, estate planning is crucial, because the only way that these organizations are going to get anything from our estate is if we plan ahead. So there are many ways you can do that. You can make a bequest in your will or in your trust. You know, I give X amount of dollars or this percent to the Lord of Life Endowment Fund. You can name them as a beneficiary on an asset like a retirement account, a life insurance policy. And you could make them a beneficiary of an account. Maybe you have a $25,000 checking account that you've just been letting sit there. That would be a good account to name that organization as a beneficiary on. And again, all of these designations can be a percentage or a dollar amount. I included this slide because there are certain beneficiary forms that need all of this information. So I know the tax ID, it seems kind of weird that it's out there, but there are beneficiary forms where you have to actually include the tax ID for the charitable organization that you'd like to leave the bequest to, and this is the tax ID that you will need for Lord of Life. And make sure you have that with you when you go to complete that beneficiary designation. If you do name Lord of Life or any charitable organization in your will or your trust or anything like that, it's a really good idea to give Lord of Life a heads up and let them know that you've done that, so that if something happens to you, they know to take action, and they can also plan ahead too. They know what to expect in the coming years, and it allows them to do some planning, and also can make it more efficient in terms of your estate once something does happen to you. We always recommend that if you're going to do your estate plan, whether it's a will, a trust, or whatever you're doing, that you round it out by completing a healthcare directive and a power of attorney form. A healthcare directive is basically you saying, if I am unable to speak for myself, let's say I'm in a car accident, I'm unable to voice like what kind of medical care I want to receive, I'm appointing an agent to make those types of decisions for me. The other thing that a healthcare directive does is it gives some guidance to your healthcare providers and your family about what you want in terms of life-sustaining treatment in the event that you're in a terminal or vegetative state. It's really important to have that in place. Appointing an agent is crucial, because if you don't have a healthcare directive appointing an agent and somebody needs to make decisions for you, we have to go to the court and have a guardianship proceeding to get somebody appointed to make those decisions for you. So this document takes 5 minutes to do. It's so worth it, because a guardianship proceeding is lengthy, it's expensive, and it's really, really stressful when you're in a situation where you're going to need a guardianship. Power of attorney is basically you appointing someone else to make transactions and transact financially on your behalf. So when you appoint your power of attorney, if something happened to you, that person is going to be able to pay your bills or access your bank account, make sure that your mortgage is getting paid, and have a right to call and get that information from your lenders and things like that. So if you don't have the power of attorney and somebody needs to manage your finances, we would have to go to the court and get a conservator appointed. Just like a guardianship, it's lengthy and it's expensive. Something you want to avoid, if you can do it with a document that takes 5 minutes, it's worth it. always happy to answer any questions you have directly. Feel free to call me, call Bill Hefner, who's my boss. We're both pretty social. We like to chat with our clients, and we're happy to walk through any questions you might have following this presentation or anything that might come up in the future.
As far as your assets and what you're going to include in your will, and Bobbi had mentioned, doesn't have to be a dollar amount, it could be a percentage. But the concept is to think about tithing a portion of your final assets to your favorite charity, to your church, to your alma mater, before the rest goes to your children. So I'll throw that out, just food for thought. But does anyone want to pose a question to Bobbi?
Say, I was just curious, is a minor 18 or 21 years old?
So a minor would be considered anyone under 18 under the Uniform Minors Act for financials.
I have a question for you, if I may.
Sure.
What happens on a contract for deed if you have one?
So in terms of real estate?
If real estate or business?
So it really depends on the terms of the contract for deed, but those are things that we've addressed with clients before. We have real estate attorneys here, which is one of the things that has been wonderful working here. If it's a contract type I haven't seen before, I'll go down the hallway to one of our real estate attorneys and get advice. But it's always going to be something that we can assign your interest in the contract for deed to your trust. Or we can plan for it depending what type of plan you're doing. You might not be doing a trust, but we can certainly help you come up with a plan.
If we get together with you for these procedures, is it going to be a face-to-face or is it going to be on Zoom?
I'm doing a mix of all of them. I have some clients that still prefer to meet in person, and I'm fine with that as long as everybody's willing to wear a mask. I still do a lot of Zoom meetings, and I even do phone meetings if you don't feel comfortable with Zoom. You obviously are comfortable with it. But yeah, it's really up to the client.
I've heard, what are the tax implications of going through probate? What is the big thing with taxes?
Tax implications for probate. So I think what you're referring to probably is my estate taxable? And currently in Minnesota, the taxable estate tax exemption is $3 million. So if your estate exceeds $3 million, it's a taxable estate. And that would be something that you would need to definitely plan for. As I mentioned, revocable trusts do allow us to do some tax planning for those high asset estates. But if you are over $3 million, you have for sure a Minnesota estate tax. If you're over 11.7 million, you have a federal estate tax. Well, you'll have your final income tax for the decedent. Yes. So we would definitely do like a income tax return. So client that passed away in 2020, maybe October of 2020, probably earned income through October of 2020. So the personal representative would have to file that final income tax return as the personal representative. And that sometimes we help with that. Sometimes the family goes to the accountant that the decedent worked with during their life. The other tax possibility would be a fiduciary tax return. And basically what that is if you have an estate that earns income, so let's say you have probate assets include like an investment account that's getting, yielding income, then you would have to do what's called a fiduciary tax return, which is another separate tax return that would be completed by the personal representative.
I have a comment, not so much a question, but my mom is 86. She's turning 87 in March. And my father died 25 years ago. They were in the middle of estate planning. He was 63 when he passed away, and they were in the middle of their estate planning at that time. So my mother forged ahead and finished, and she has a trust, and she has a will, and she has farmland, and you know, a lot of different things. But anyway, she wrapped it all up. She was 61 at the time, and she wrapped it all up and it was all done. And so she didn't worry about it. Well, she pulled it out about 2 years ago. It was unbelievably out of date. She had to redo the entire thing. So my advice is, if you have an estate plan or you have a will or any of the things that Bobbi's been talking about, you need to look at them about every 5 years and make sure that some events haven't happened in your life that have changed what you put in there.
Yes, that's absolutely true. We recommend every 5 years. If you have any life change, like a spouse passes away, you get married, have a new child, new grandchild, something that you want to provide for, it's always a good idea to come, or even a phone call to your attorney and say, look, do I need to worry about this? Usually I'll say, well, give me more information and then I'll tell you if you need to worry about it. But, you know, something we do for our clients too is, you know, when you come in every 5 years or so, we're going to look at it and say, yeah, you might want to change this. And if you decide not to do it, you're not going to get charged because we just reviewed it. You're going to get charged when we actually start making changes.
I have a question.
Sure.
Talked about three things. And, you know, in a lot of people's cases, it's relatively simple. You have some investments or retirement funds, and you might have a home.
Mm-hmm.
You don't have a lake cabin, you don't have property, you don't have any other things other than your retirement investments and so on. Obviously they work with you, but if you just want to say, I want to lump all of these assets together at some point in time and say, I want to give 15% to my designated charity and the rest goes to my kids and so on, you can lump them all together. You don't have to make special arrangements in a trust or special arrangements in the will or anything like that, correct?
No. So let's say that you probate proceeding lumps everything together.
Yeah.
So if you don't have a trust and you have a will that says 15% of my entire estate goes to this church and the rest goes to my children in equal shares, everything gets lumped together and that's how it gets distributed. And that's called the residue of your estate. Whatever's left over after your final expenses, your funeral expenses and your last medical expenses, those types of things, and tax bills are paid, everything else is the residue of your estate. And that would go exactly like that.
Okay.
One more question?
If I can just add one thing. I'm the regional gift planner for the ELCA, and a gift planner is a little different than an estate planner, but in lumping them together, you would have to pay taxes on like retirement accounts and things like that, and you could gift that to a nonprofit and not end up paying the taxes.
Yes.
So that's how I work with people also, and I'm sure you do too.
Yep.
And so, and there's no charge or anything. It's just advice. So
Yeah, that's a great point.
Question: if you have a living trust, so when you die, everything goes into the living trust right away. So if you have outstanding bills like medical bills and that kind of thing, the trust doesn't really owe them. I did, but I'm not here anymore. So do they take it out of the trust, or do they how does that work?
It depends. It depends what kind of debts they are. So if let's say, for example, that you have credit card debt, the creditors can only go after your probate estate, your probate assets, but there are certain types of creditors that can go after more. Those types of creditors would be like the county for someone who received medical assistance. They can get through anything. They're going to get everything you have until they're paid off. But if it's a credit card company, as another example, it's a little more complicated for them. But remember too, if you have assets that are not funded into the trust during your lifetime, but are going into the trust after your death, that would have to go through probate. So unless you have everything in your trust, if you have assets that are going to kick you over that $75,000 outside of your trust, you're going to have to go through a probate proceeding, meaning you had probate assets. So those assets that weren't funded during your lifetime are subject to creditor liens.
So what about a car or the personal property within your home, not my home?
That would be considered your personal property, and technically, yes, it is subject to creditors if it's outside of your trust. So if you don't go to the DMV and title your car under the name of your trust, it technically is subject to creditors. Usually our cars aren't going to kick us over that $75,000 mark, so we don't worry about it necessarily. But you might be one of those people that has really valuable cars, and many of them. In that case, you might want to consider titling. Yep.
I was
Thanks
just
so
going
much.
to add, reminding your adult children too, especially if they have children, even if they're 25 or 30, and it's important for them to start thinking about stuff earlier rather than later, especially if they have little kids. So.
Bobbi, thank you very, very much.